C21 18375 1 Martinez versus Ford Motor Company. Counsel, make your appearances.
Lauren Subar on behalf of the plaintiffs, Your Honor.
Deborah Bullion on behalf of Ford Motor Company.
All right, let's go ahead and proceed.
It's always one of those interesting questions on which side is going to proceed, Your Honor, in these, because I think it started with Ford filing a objection motion to quash the deposition based on initially on time and place. I think what started the ball rolling is also in their motion, they indicated that they would be making objections to the scope of the notice of deposition. We filed a motion to compel the deposition based on their motion to quash. They filed objections. We filed response to the objections. So I don't know where in the process you want to start there, Your Honor, because there's kind of motions and responses, but the response is really a motion, those kind of things.
Yeah, let's just start with we're trying to get a deposition set. So have you worked out time and place yet?
Your Honor, we preliminarily did. The notice came in for March 15th. Initially, we had a conflict, and we also objected to the breadth, which we'll get to in a moment, of the topics. I then sent an email to Mr. Tracy and said, we've resolved the conflict on the 15th, but we still have these problems, and sent several emails to try to meet and confer, and there was no interest in conferring with us at all. The response I got back each time was just set it for a hearing. And so there's been no conference at all as required by the local rules to confer on the scope. But in response to that, I got back and said, can you get me some dates in April? So we still are available March 15th, but I don't know if Mr. Tracy wants us to look to April, which we'll be willing to do and happy to do so if he's not available on the 15th. So that's kind of a yes and no as to the date and the time, basically.
I apologize, Your Honor. I do not have Mr. Tracy's schedule. I don't think that the time and place and Ford's counsel will agree. I think will agree with me. I think really the issue today, Your Honor, goes more to the scope than to the time and place. I'm more than happy to be proven incorrect on that, but I think our discussion days goes more to the scope, Your Honor.
I mean, we're going to need to deal with all those issues. You need to have Mr. Tracy, so if he's going to cover it or if you're going to cover it, you need to have his calendar ready for this. And so, because I don't want to have to do this piecemeal, one option would be, could we just reset the hearing and I could send you to confer, or you can't get somebody who has it.
I absolutely can, Your Honor. And if you can give me 30 seconds to walk down the hall.
Yeah, go ahead and get that person, and let's get the time.
Sure. I will do just that. Thank you, Your Honor.
And Your Honor, my witness is available on the 15th, assuming the scope is not tremendously expanded from what we envision it to be. If Mr. Tracy can't do the 15th, then he offers dates in April. I will need to contact Ford as to the availability of the witness. Then I can look at my calendar certainly, but I can't speak for the witness.
You may want to get the witness on the phone, because I'm going to order a particular date and that witness will have to be available. So you may want to call the witness and find out, get them on the phone, just like he's getting Mr. Tracy.
Okay. And I can certainly do that, Your Honor, if it's within the scope that I envision. If it's well beyond that, we may need to get an additional witness that I don't know who that would be. So, but I can certainly see if I can reach him. They're in Michigan, but I can certainly see if he is available to have his calendar available.
Do that, yeah, just to make this.
Okay. I'll send an email to him. And so whenever Mr. Subar comes back, I can have him plug in.
Thank you very much both for your indulgence. The March 15th would be fine, or anytime in April that meets with their needs is also fine.
Okay.
Okay, so we're going to set on March 15th. What's the location?
Anyway,
I'm sorry.
there is no issue, I don't think, with regard to the location.
Where is it? Just so I know.
We offered if they want in person to be in Detroit, or we're willing to do it Zoom.
Mr. Subar, what is your?
My guess is Zoom would be fine.
Okay, so it'll be on Zoom, and so you guys have not conferred on the scope yet?
It's the scope, I think, that's the issue, Your Honor.
Okay, right now, just so it's clear, I'm ordering the deposition to take place on June,
March.
On Zoom, and you guys have not conferred on scope at all, so I'm going to put you into a breakout room so you can confer on scope, and then when you're done, just come back to this room.
Okay.
Okay.
Thank you.
It's just the two of you guys that should be in the breakout room,
Yes, Your Honor.
and that's D. Bullion and Warren Subar. Is that right?
Yes.
We don't need to send Josh Brake or Jim Robertson to the room.
No, Your Honor. Not, this is Jim Robertson speaking. I'm here on the 9:30.
Oh, great. Okay. All right, we'll take care of you guys now. It's a little bit early. Oh, no, it isn't. It's right on time. So we'll go ahead and go to your case. This is a motion for continuance. So let's, and I think it's the defendant's motion for continuance. Let's go ahead and proceed. Do you want this continuance motion?
It doesn't matter to me, Your Honor.
So, right.
Good morning, Judge. How are you doing?
Good, good. Do you want a record for this, or it's on YouTube, but do you want the court reporter to do this? We don't usually do continuances.
I don't think I need a record, Judge. Jim, do you need a record?
I don't know.
Okay.
Well, let's go ahead. Let's start argument then.
So Judge, this matter, I believe Mr. Robertson also filed I believe perhaps a motion to abate / motion for continuance on this. This is one, it's kind of a unique case. It involved a commercial contractual dispute where an individual was sued, who's a defendant, Dr. Bronk. Our main argument was that this was done in a corporate capacity, any transactions, and so we couldn't necessarily file a counterclaim. And so we filed a separate lawsuit in federal court. That federal court proceeding was an analogous proceeding, but had similar but different parties from our standpoint. It had the corporation that my client was a part of. The parties went to a mediation as required in the federal court and were able to resolve both matters. Those matters require payments over a scheduled period of time over the course of about 3 or 4 months. The last payment would be due sometime in June. And so the parties have agreed that if the payments are not made according to the agreement, then a agreed judgment for a different amount would be filed and executed upon. And so what we were asking the continuance for, or an abatement alternatively, is to allow that time frame for those payments to go by. Other than that, this case is essentially resolved on the merits, at least, both this case and the federal court case. It's just a matter of instituting the payments. And so we'd agreed to at least have some sort of recourse in the event that the payments were not made pursuant to the agreement. And so one way would be to either just continue the case past the time that the payments are due, or alternative to abate it and then reinstate it to issue dismissal documents.
Why don't we do this? Why don't we reset it to August? The trial setting that I'm hesitant. This has just been after years of experience to abate cases, and I absolutely have to, because then it goes on an inactive docket, and it gets much more difficult to monitor it. And I've had so many cases over the years that have been abated, then unabated, and then they're 3 years later, and we haven't been monitoring them because they're on the inactive docket. And anyway, it just, from a court administration standpoint, is a lot better. So would August, how long would a trial take in this case if we did get a trial?
Assuming a no trial would be needed, it would just be that if the payments are not made, then it would just be an execution of that judgment. So a day at the most, I would assume, if a trial was needed. So
why don't we that for trial on?
Your Honor, I think there's a jury demand in this case too. So if a jury trial were to be held, it'd take longer than a day, probably take a couple days.
Want to go ahead and reset it to August 8th? Does that work for you guys?
that works for us, Judge.
Let me pull up the calendar, Your Honor.
And please, if everything works out, please get us a dismissal on this way before then.
Absolutely, Your Honor.
August 8th is good with me, Your Honor.
Okay. All righty, guys. You have a great rest of your day. We're on to reset this to August 8th.
Judge, there was one more issue we wanted to discuss with you. Jim, do you want to address that with the court, or?
Which one is that?
With respect to the mediation order?
Yes, Your Honor. The court, Your Honor, ordered mediation in this case with Frederick Lewis, I believe is the mediator's name. I haven't received it yet, but checking the online docket, saw that there was an order entered awarding a mediation fee to him. The case was never mediated with him because it was mediated with the mediator appointed in the federal court and resolved, so there was no need to mediate this case separately. We don't have a motion on file with the court right now, but I just bring this to the court's attention, and would, to the extent I can do it orally in this this venue, this hearing, I would move the court to vacate that order.
I'm just gonna, I'm not gonna enforce the order. I'm just gonna leave it in place. If something happens and the settlement goes cattywampus, then you'll have to mediate. But I'm not gonna make you mediate if you don't need to. So
okay. There's an order though awarding the mediator a fee of Judge, I don't remember how much it is.
That order, okay. So and you guys never actually mediated.
Right. We never actually mediated with him because we settled the case and didn't need to.
Go ahead and get me an order vacating that order. I'm sorry, not the order itself, but the fees order, so mediation fees order. So yeah, go ahead and get that to me and I'll go ahead and vacate that.
All right. Thank you, Your Honor.
Thank you, Judge.
Anything else, guys?
I think that's it for today.
You guys have a great rest of your day.
Thank you, Judge.
You too. Thank you, Your Honor.
Hey, are both sides here? It's a little bit early. Are both sides here on the Baker v. Fuller case?
Both parties and defense counsel is. I haven't seen plaintiff's counsel.
It's on Zoom, so it's
he's here, Your Honor. Mr. Sasson.
Hi, Your Honor.
hello, guys. Apparently we're currently in trial with Mr. Patterson, where the jury is deliberating. We may be taking, who knows, we may have to take a break any second now. So you guys are requesting a special setting. So I'll start off by kind of giving you the special setting speech. I'm sure that you've already heard it, Ms. Ferris, but I do this in every case. So I do special settings on cases like this. And in fact, I think the case that currently got tried was, I believe it was a special setting. I do that because I think that there's some cases that have very high expense that you don't want to have to get reset over and over on. And but I typically medical malpractices will fall into that category. This is the caveat, though, is if you pick a date and you're specially set, it does not get moved. And the reason for that, my reasoning is that I'd stop setting cases during that time. You've cut to the front of the line in front of cases. This case is not terribly old. And so I always urge people. I had a plaintiff's attorney, a young plaintiff's attorney at one of the big plaintiff's firms here in town, who did this once to me. He basically used the special setting as a tactic to try to get the defendant to settle. Then when we got to the day of the trial, I said, well, Judge, we're not ready. And so there's just not, I want to make sure that you guys are ready to have a special setting. I'm going to give you one, and I'm okay if you wait to request one. But if we pick a date and it gets set, then you have to go on that date. And so do both sides still want a special setting? Is this case ready for a special setting? If you have a lot of discovery left to do, it may be better to wait to pick a date, because once you're set in stone.
Your Honor, Gabe Sasson here from the plaintiff. We're ready. We've discussed it with defense counsel, discussed it with our expert, and that was one of the reasons, as you know, MedMal, our expert is coming in from Maryland. The date that we asked for is August 1st of 2023. I think that's a Tuesday.
So unfortunately, I have a problem with that date unless this is going to be a one-day trial. I could get, I'm not sure really the best way to do it. I'll be there that Tuesday, but the rest of the week I have a trip with my son. So I could get a visiting judge maybe, but it'd have to be done in a week because I'll have trials the next week, or we could reset it to a different date.
We can try to get a different date. I don't know. I can talk with defense counsel about it, but because we had already kind of talked about some dates, I think that we were looking into November was our next available date. Hopefully we can get something a little sooner than that. Is the best way to go about it is to get with your court coordinator to try to figure out the best dates?
Not really. It can be. I mean, she'll know when the special settings are, but she may have given you this date. She doesn't know that I'm going to be gone those 3 days. Why don't I give you some dates? What time frame are you looking at? Like I could do August 8th if that worked. I could do August 15th. I could do August 22nd.
Okay.
Let me just see this. I have a special setting at the end of the month. Let me see what that is. I'm not. Yeah, let's see. I don't think we should do September 5th because that case may carry over. Let me see. I could do September 12th. I could do September 19th. That's a particularly good day.
Gabe, what does August 8th look like for you?
I'm trying to find that email from my expert that talked about when she was available.
Because as I'm looking at Ken's calendar right now, it looks like he's available. He's not available the week of August 14th or 21st. But it looks like he's available that week of August 7th. So a Tuesday start, August 8th.
I think that might actually work. Let me just look real quick.
The only caveat to that is it would have to be done by Friday because he has a vacation letter in the week of the 14th and the 21st. So unless we want to look at September. I believe Judge Hoffman, you said the week of September 12th.
September 12th or 19th would work. I'm trying to find when, I don't know if the Dallas Bar has sent their bench bar date. I can't find it. Let me see if I can text somebody. It's usually the last week of September, but I think they may be different this year. Let me see.
We're in trial the week of September 25th. So that week won't work.
Yeah, I think August 8th unfortunately won't work. So if we are looking at September, I think September 19th would work from what I can tell.
All right, let me look here. Let me just make sure.
I'm perfectly okay with putting you guys into a breakout room so you guys could talk this through. I'm not trying to pressure you into a particular date. I know that you may need to talk to experts and all that kind of stuff, but once you get a date, you're kind of stuck with it. So I'd hate to have you. Let me give you some other dates. October 3rd would work, I think. I don't know when bench bar is. October 10th, October 17th, October 24th, October 31st. November 7th is a non-jury day, so we'd have to work around that. Anyway, those are the dates I'm going to give you right.
Okay. And do you want us to go in a breakout room or just talk about it and get back with the court?
I think the best way to do is go into a breakout room. I hate that you guys picked that August 1st date. Ron, I just haven't told Rhonda about, there's certain things I know in my schedule that can cause. So it's better to have me here to kind of, make sure that those are good dates. So happy to put you into a breakout room so you can talk about it and then you can come back.
Okay.
That'll work, Your Honor.
Let me see if I can create another breakout room. I should have done that to begin with. And I'm gonna have, I don't know any other way to do this. I guess I have to close. I already have a breakout room. I didn't create two. I should have done that. Let me close them. I'm gonna bring them back in, and then I'm gonna create 3 breakout rooms so we have enough rooms for everyone. Okay, I've been told that the president of the DBA says it's probably going to be September 28th is the bench bar. So I'm going to avoid that. Okay, give me 1 sec. Okay, first off, I'm going to go ahead and put Mr. Sasson and Ms. Ferris into a breakout room. Okay. You should have gotten, if I'm doing this correctly, Ms. Sasson, Ms. Ferris, did you get a invite to room 2? Ms. Ferris, okay, I guess they did. And then Miss Bullion, you, Mr. Subar, are you both here?
He was here. We were in the midst of talking and then it ended the session.
Yeah, that was, let me go ahead and I'm going to move you back into the breakout. I'm not sure what he's doing, so I'm going to move you into a breakout room with this.
Okay, I've got one to join in room 1. Should I click on join on that one?
Yeah, go ahead.
Okay.
You're still working on it, I guess. Okay. And Mr., I'm sorry, I'm gonna butcher your name, Mr. Dami.
We say it a little bit easier, Neswadomi.
Neswadomi. All right, I'll get that down. Neswadomi. Mr. Neswadomi, what are you here for, sir?
I'm an economic expert, an economist.
Is this for a particular case?
Yes, I thought,
Adams v. Flower Mound?
yes, and the attorney that spoke with me is Chris Carr.
Okay.
Am I too early? I thought they said to get on a few minutes at 10.
Early, so you're welcome to stay on and just turn your camera off or whatever you'd like to do.
Okay, thank you.
Ms. Ferris, Mr. Sasson, are you both in here?
Yes, Your Honor.
Yes, Your Honor.
Rhonda, are you there? All right, well, go ahead and, there you are. Okay, so what did you guys decide?
I think we're gonna go with September the 19th, Your Honor.
That's the winner.
September the 19th is the winner. And bench bar, just, I mean, one caveat, I just got confirmation and I'll put that on my calendar. Bench bar is going to be September 28th and 29th. So you feel that's that's the end of the week. So I would assume you'd be done by then, right?
Oh, yes, sir. I believe we both have trial settings the week of September 25th. So we are hoping to get this one done in 3 days.
That's correct, Your Honor.
Okay. All right, sorry, I'm just trying to juggle a bunch of stuff at the same time. All right, so September 19th, go ahead and specially set that. You check with your experts, everything is good, right?
That is correct, Your Honor.
Yes, Your Honor.
Never hold your peace. And you finished discovery, you've been to mediation, the whole bit.
That's correct, Your Honor.
I believe, yes,
No, yes?
yes.
Okay. All right, well, just realize that it's not an excuse to continue this if you haven't finished mediation, you haven't finished discovery. Now, if one side, you know, if Mr. Sasson is dragging his feet on setting a mediation date, Ms. Ferris, you really want to get it set, you come to me and say, hey, look, Mr. Sasson won't mediate, and I will make sure he gets into a mediator. You guys get into a mediator. So I don't want you to think like I'm not going, but don't wait until the day of trial to do that. Let me know, you know, a month in advance, and we'll twist some arms. This case has it been to mediation, you said, or not?
It has.
Okay, doesn't matter then. All right, guys, you have a great rest of your day. And Ron, did you get the date there, September 19th?
Yes, I did.
All right, you have a great rest of your day.
You too, Your
Thank
Honor.
you, Your Honor. Bye-bye.
You have another Gail Fisher binder in here. Did you want me to bring it in there for the 11 o'clock?
Yeah, go ahead.
Okay.
Why do they have a binder for me? That's just kind of silly. Hey, it's hard to tell right now. Let me see if I can turn some of my video. Let's see. But the stuff you can tell right in here on my screen, it's like really dirty. Do you have anything that we could clean this or computer screen? Okay. And I don't care.
Morning, Your Honor.
Morning, everyone. Okay, both sides here on the Adams case.
I do not think the defendant is here yet.
Okay. No worries. And you see that Mr. Niswadam is here. I don't know if he's your expert or their expert.
He's our expert, Your Honor. He's our economist.
Okay, he's been here for a bit.
Yeah, sorry, I came in a little early. Apologize.
No worries. Just so you kind of know from a scheduling standpoint, we have a jury deliberating right now, and we have somebody in a conference in one of the breakout rooms on a products liability case. They're conferring on a motion to compel, and so they may be joining us too. So is Diana Faust on your case? Okay. That's weird.
Good morning, everybody.
Morning.
Good morning.
All right, is everyone here on the Adams case? We're still waiting on some folks.
Your Honor, this is Chris Carr for the plaintiffs. I think Mike Lyons is signing in, but we can move forward if the court is ready. We've also got Jeff Levenger here. He's our appellate counsel.
What about for defendants?
Nadia Sheik is currently here for defendants. I believe Casey Campbell will join as well as our appellate counsel, Diana Faust, but similar to Chris, we can get started if the court would like and they can join.
So I exclude anybody, and I just got this.
You see Diana just joined from our side. So I think for us, we're just waiting for Casey, Your Honor.
Mr. Campbell signing on right now.
Your Honor, I believe Mr. Campbell got on. Oh,
And there's Mr. Lyons, so I guess we can get started.
yeah.
Your Honor, are you ready?
Yeah, let me go on the record on, Tony, are you ready?
Yes, Judge.
On the record on DC 20-17490, Adams v. Flower Mound Hospital Partners. Counsel, make your appearances.
Chris Carr and Jeff Levenger for the plaintiffs and Mike Lyons.
And Nadia Sheik, Casey Campbell, and Diana Faust on behalf of the defendant.
Okay, let's proceed.
Your Honor, thank you. Just a brief intro. Dr. Neswadomi, Professor Neswadomi is an economist. There was a December 2 2022 stipulation regarding him offering testimony regarding net present value of future medical costs if the parties could not agree. The court accommodated us because Dr. Neswadomi was not available this afternoon. There is a hearing set this afternoon on the plaintiff's motion for judgment and the defendant's motion for periodic payments. And I understand the purpose of our time this morning to be to offer Neswadomi's opinions and testimony. So that's what I'm going to do.
Any objection?
No objection, Your Honor.
All right, Dr. Neswadomi, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Dr. Neswadomi, would you please state your full name, address, and current position for the record?
Michael Lewis Neswadomi. I live at 2113 Pembroke Place, Denton, Texas, 76205.
I'm sorry.
I'm currently a professor of economics at the University of North Texas.
And Dr. Neswadomi, you mentioned this, you're an economist, correct?
Yes,
What has your role been in this case so far?
I was asked to evaluate the present value of the life care plan prepared by Dr. Altman for Miss Jessie Adams.
Before we get into that, I want to get some information about your credentials into the record. Your Honor, can I share screens so I can show some exhibits?
Go ahead.
Let me find. Dr. Neswadomi, I'm showing you what's been marked Plaintiff's Exhibit 454. I believe it's been pre-admitted, Your Honor. Is this a copy of your 2022 CV with a listing of your testimonial experience appended to it?
I can't see the CV. It just shows your computer screen.
Oh, I'm sorry, Your Honor. I've got it on the wrong screen. Let me try now.
There it is.
Is that better? Yeah. Dr. Neswadomi, is Exhibit 54 a copy of your January 2022 CV that shows your education, training, experience, and publications that has your testimonial record appended to it?
Yes,
Okay, and I emailed this to you last night, so you were familiar with the exhibit before I used it, correct?
yes,
Okay, Your Honor, I believe this exhibit has been pre-admitted, but for safety's sake, I'll move to admit it since Dr. Neswadomi never appeared at trial.
Any objection?
No objection, Your Honor.
Okay, Dr. Neswadomi, tell the court a little bit about.
Oh, yeah, wait, can you guys not hear me? Let me admit the exhibit. She offered it and I didn't get a chance to admit it, so you gotta let me admit it.
Oh, I'm sorry, Your Honor. I heard something different, but okay.
Exhibit 54 is admitted.
Dr. Neswadomi, tell the court a little bit about your background, training, education, and experience as it comes to determining the net present value of medical life care plans and personal injury cases.
I have a BA in economics from the University of Dallas. I have a PhD in economics from Texas A&M University. I'm a professor of economics, or have been a professor of economics for 38 years at the University of North Texas in Denton. I'm past president of the National Association of Forensic Economics. I'm a past editor of the Journal of Legal Economics. I'm a past president of the Dallas Economists Club. I've published over 50 articles in economic journals and 18 book chapters in one book. And I've testified in state and federal courts.
To your knowledge, Dr. Neswadomi, has your testimony ever been stricken or limited in a case in which you created net present value calculations based on a life care plan in a personal injury case?
Not that I'm aware of.
Will you tell the court, generally speaking, what you did in this case?
I examined the life care plan prepared by Dr. Altman for Jesse Adams, and I projected future inflation rates in various medical expense categories and discounted them back to the present value.
Your Honor, may I share screen again?
Yes,
Your Honor, can you see the life care plan?
yes,
Okay, so this is a demonstrative, Your Honor. It has not been offered into evidence and will not be. Is this the July 6, 2020 life care plan initially prepared by Dr. Altman, which you analyzed in this case?
Yes.
Okay, I want to point out something on page 32 of this life care plan. Did Dr. Altman make his cost analyses based on present costs of the future anticipated goods, services, and products, or did he find future costs?
In his report, he specifically stated that the life care cost analysis is presented in specific categories designed to aid economic or financial experts with long-term financial planning and resource allocation. No adjustments have been made within the context of this plan for inflation, projected real rates of growth, or present value.
So whose job was it to determine, for instance, if Dr. Altman reported on the need for a service 8 years after he examined or last examined Ms. Adams, whose job was it to figure out what that service is projected to cost in the future, his or yours?
That was my job.
Okay, and did you do that?
Yes.
Tell the court generally how you did that.
There are a variety of healthcare expenses such as physicians, hospitals, pharmaceuticals, home health care, and others. And within each of those categories related to the current costs that are in Dr. Altman's report, I projected the increase in those costs in real inflation adjusted dollars, and then I discounted them back to the present value.
Got it. And do you remember for the first life care plan done by Dr. Altman, what his sum total not adjusted to net present value was in July of 2020?
I believe it was $2,825,359.03.
Okay. And did you reduce that number to a net present value?
Yes.
Your Honor, I'd like to share screen.
okay,
I'm showing you what's been marked Plaintiff's Exhibit 59A. Is this a summary of your calculations that reduced the July 6, 2020 life care plan of Dr. Altman to net present value?
Yes.
And Your Honor, I believe this has been pre-admitted, but I moved to admit this exhibit. I don't think there's been an objection to it.
any objection?
No objection, Your Honor.
Plaintiff's 59A is admitted, and have you provided these to Tony, these exhibits?
They were provided in the original court record, but I will provide them to Tony right after this hearing.
Great.
Okay. Dr. Altman, after you projected costs for services, products, and any other help that Dr. Altman determined in the July 6, 2020 life care plan into the future and reduce them to net present value, what was the net present value you determined to be of the July 6, 2020 life care plan?
$2,795,044.
And for the court's benefit, did Dr. Altman project 5 years into the future, 10 years into the future, 15 years into the future? How many years out did he go?
Well, he projected her life expectancy is roughly 10 more years.
And so you grew future costs for 10 years, correct?
Yes,
And then you discounted them to net present value.
yes.
You didn't do that for 15 years, did you?
No, I don't believe so.
Okay. Has anyone, to your knowledge, done that for 15 years?
I'm not aware of.
Okay. So after you did your initial determination of net present value, what else were you asked to do in this case?
Dr. Altman updated his report, and I did the same kind of analysis on that updated report.
Do you remember? Well, let's just show it to you. Does this appear to be Dr. Altman's second supplemental report with regard to Jesse Adams?
Yes,
And is this the update that you did based on Dr. Altman's second supplemental report of October 25, 2022? Is this what you worked from?
yes,
And he determined at that time care needs of 2.181 to 58.06 million and potential care needs of $38,804, correct?
yes.
Okay, and what did you do with this updated life care plan?
I did the same thing as I did with the first report. I projected increases in the medical care expenses by the various categories and discounted them back to present value.
Dr. Neswidomi, I'm showing you what's been marked Plaintiff's Exhibit 59D. Is 59D a summary of your mathematical calculations whereby you grew future costs and then discounted them to net present value?
Yes,
Your Honor, I believe 59D has been pre-admitted without objection, but I move to admit it out of an abundance of caution.
Any objection?
No objection, Your Honor.
59D is admitted.
Dr. Neswidomi, again, did Dr. Altman project 15 years into the future, 10 years into the future, 5 years into the future?
10 years into the future.
Okay. And were your calculations based on 10 years into the future?
Yes,
What was the net present value that you determined to be of Dr. Altman's second supplemental life care plan?
$2,056,705.
Okay. With regard to the two analyses you did, which we have discussed, did you follow methodologies that are outlined in economics literature and case law?
Yes.
Tell the court about that.
Well, I projected the future medical cost increases based on historical evidence from a peer-reviewed journal in the Journal of Forensic Economics that comes to the conclusion that since around the year 2000, that this time series in these costs is roughly stationary and provides a good basis for projecting into the future.
I have the same question for the methodology you used to discount the net present value. How did you determine discount rate, and tell the court a little bit about the methodology you used?
Following that same article, looking at is there a stationary relationship between the medical care inflation and interest rates, and I used U.S. Treasury 3-year Treasury bonds as the discount rate.
Is it your opinion within reasonable probability that your net present value calculation of $2.795044 for Dr. Altman's July 6, 2020 life care plan is reliable and accurate?
is that the updated one?
No, that's the first one off the July 6th plan.
Oh, okay. I'm sorry. Could you repeat the number?
Yeah, 2,795,044.
Yes.
Okay. And I have the same question for the second calculation you did off Dr. Altman's October 25, 2022 supplement. Is it your opinion that the $2,056,705 number you determined as the net present value is accurate?
Yes.
Do both of those numbers follow established peer-reviewed methodology?
Yes.
After you did those two analyses, the jury awarded $3 million in future medicals to Jesse Adams in this case. Did you become aware of that after trial?
Yes.
What did I ask you to do with that?
You asked me to make an approximate calculation of what the present value of that would be.
Will you explain to the court how you did that and what methodology you used?
I did not know how the jury determined the 3 million. So what I did was take a ratio of what the present value was in Dr. Altman's second report of my present value number to his unadjusted number, a simple sum of all those numbers, and that came out to 94.3%. And so I took, 94.3% of the 3 million came out to be $2,828,696.
And do you believe that under the facts of this case to be a accurate calculation of the net present value of the jury's award of $3 million in future medical expenses?
Yes.
Okay. Tell the court why you believe that to be reasonably accurate.
Well, I'm looking at the, as I mentioned before, what is the relationship between medical care expense inflation rates and U.S. Treasury bond rates, and over the at least the past couple of decades or even more, the relationship has been fairly stable. It's close to almost a net offset. The growth rate in medical care expenses has been approximately equal to interest rate on U.S. Treasury bonds.
So it's essentially a near 1-to-1 ratio.
Almost.
So the $2.828,696 million to which calculation to which you testified, that is net present value as well, correct?
Yes.
And you believe it to be reasonably accurate?
Yes.
I have only a few more for you, Dr. Neswadomi. You have become aware that a motion for future periodic payments was filed by the defendant in this case, correct?
Yes.
I want to suggest a hypothetical to you. If there is argument that future periodic payments should be based on your calculations of net present value figures, how do you respond to that?
Well, if they're periodic payments for into the future to have the same present value, they can't simply just be divided by the number of years that they're going to be paid. They would have to be increased such that then when they're discounted back to the present, it yields my number of $2,828,696, roughly the $3 million award.
If net present value figures that you determined over a 10-year period are simply chopped up and spread out over 15 years without looking at what those future costs will be, will that result in sufficient compensation to Jesse Adams, a windfall to compensation to Jesse Adams, or more likely than not, her not having enough money in the future?
The last one, it would not be enough money for in the future
And why is that?
because there will be in increases, inflation rates in these medical care expenses.
And to the extent folks are using your numbers to make future calculations, that's not what they were designed for, your numbers, correct?
Right, they have to be projected into the future and then discounted back. So they would need to be larger numbers in the future than simply just dividing them, that number, my present value number by 15 and spread them out over 15 years.
And we already mentioned this, but if they're using Dr. Altman's numbers, were those numbers determined by Dr. Altman based in costs today? Or were they based in costs that he determined were projected for the future?
His report is giving estimates of the cost today.
And so if his report numbers are used and chopped up and spread out over 15 years, does the same result occur? More likely than not, Jesse Adams will not have enough money to cover future increased costs.
That's correct.
Pass the witness.
All right, Dr. Nispadomi, my name is Nadia Sheikh. I am one of the attorneys representing the defendant, the hospital in this case. It is nice to meet you, albeit virtually.
Nice to meet you.
So you were brought on to evaluate the present value of Mr. Altman's life care plan, correct?
Dr. Altman's life care plan, yes.
Dr. Altman's life care plan, I apologize. So let's start at the most basic level, or what I would say is the most basic level of this, what present value is. So Dr. Niswadomi, would you agree with me that present value is the amount of money which, if invested today at an appropriate interest rate, will grow into a given future value?
Yes.
And I, in all fairness, pulled that from your November 2nd, 2022 report on page 3. So present value, again, if it's invested today, correct?
Yes.
And yet, Dr. Niswadomi, you used historical interest rates in your calculation, correct?
Yes.
Rather than going and pulling what the interest rate today or on that day would have been, correct?
Yes.
So present value, or let me actually strike that. We cannot invest money today at a historic interest rate, can we?
That is correct.
Okay. Now I want to shift gears and talk briefly about the inflation component of your calculation. Am I correct in understanding that you used a historical inflation period?
Yes, since 2000.
And was it 2000 to about 2020? Is that correct?
Yes, 2021. Yes.
Now, Dr. Niswadomi, have the rates in the 2000s been consistent with the rates in the 2010s?
Well, they vary by year. In this article, the authors said the evidence indicates that we have a stationary period. There is always some movement in interest rates and inflation rates in medical care costs.
Absolutely. Now, would you agree with me that looking at an approximately 20-year period would inflate the overall average?
Well, no, because you're confused. You have to tie this to the interest rate as well. So it's how they move together.
Absolutely understand that there's the interest rate as well as the inflation. And while they're somewhat separate, they come together. But had you used a 10-year inflation period, could have been vastly different than your 20-year period, correct?
I would have to look at that. I don't know that'd be vastly different. It depends which particular years you look at.
Correct, exactly. Now, I know that Mr. Carr went over some of Dr. Altman's reports with you and what you used from those reports to then calculate a present value. But the final report from Dr. Altman for the future life care plan, the amount for Mrs. Adams was approximately $2,181,000 and $258,000, correct?
Yes. $258, but that's okay. Yeah.
Sorry,
you said 1,000 at the end. That's okay.
But I apologize. Math is not attorney strong suit. But And you're also aware, as you testified, that the jury in this case delivered a verdict awarding 3 million for future medical, correct?
Yes.
Dr. Nispadomi, have you been provided a single report from Dr. Altman showing that Mrs. Adams would need $3 million in future medical care expenses?
No, I believe we talked about, I've received 2 reports.
Correct. And neither one of those reports show that Mrs. Adams needs $3 million in future medical care needs, correct?
The first report is $2,825,359. So fairly close to 3 million, but it's not 3 million.
Correct. Now, Diana, do you have any questions for Dr. Nispadomi?
Objection, Your Honor. I didn't know we were going to have more than one lawyer asking a witness questions.
Your Honor, I don't believe she has any questions anyway, so I will just retract that. We pass the witness.
I have no correct, Your Honor.
All right, and so we are gonna have another hearing, I guess, at 3:15, I think. Is that right?
That's correct, Your Honor.
I did, since we're here, I did want to make sure that you guys were prepared for this. There seems to be a difference of opinions on what the taxable court costs are. So make sure you have an itemization, or maybe you guys confer on that. If it's true, I think they said in their response that it sounded like some of the things that were being requested may not be taxable court costs. Have you guys conferred on this at all?
We haven't conferred on it, but I can drop a link to all of the receipts. It's prepared to opposing counsel, and we'll talk before the hearing.
Because they say that you requested copies of pleadings, discovery, or trial filings. That's not recoverable. Fax filing fees, I'm not sure what that means. Copies of videotape of depositions, that's not recoverable, I don't believe. And copies of trial testimony, I'm not sure if that's recoverable or not. So if you guys want to discuss that, discuss it.
Yes,
We'll-
Your Honor.
We'll do that, Your Honor, and I for the court, I believe that the prejudgment interest rate has also been adjusted up since we submitted the last judgment from 7.5 to 7.75.
Okay, so do I need to get a new judgment potentially?
Yeah, we're probably going to have to.
Sounds good.
Okay.
Great, guys. We'll see you back at our next hearing.
Your Honor, is Professor Neswidomi excused?
Any objection to excusing him?
No, Your Honor.
All right, thank you, guys.
Thank you all.
Everyone, see you later.
All right, there's Leslie Terry and a Jack Luckett. What are you guys here for?
The 10:45 hearing in Jane Doe versus Massage Heights, Your Honor.
Miss Terry, what are you here for?
She's with me, Your Honor.
Okay. Sounds good.
And the plaintiff's counsel had had a conflicting hearing that was supposed to happen already, and I think she's a little delayed, and I wanted to make sure that message got to the court.
Got it. Yeah, I saw that.
Okay.
There's Eric Johnson here. What are you here for, Mr. Johnson?
I was sent the email
For what case?
for this case.
Okay.
He's a pro se defendant, Your Honor.
Okay. Sounds good. Okay. Y'all are here on the Doe versus Johnson case, correct?
Yes, Your Honor.
Yes, Your Honor.
Tony, you ready? Let's go on the record on DC 228680, Doe v. Johnson. Council, make your appearances.
Anjali Nigam on behalf of Jane Doe.
Jack Luckett on behalf of defendants, Massage Heights Franchising LLC and Pegasus Retreat Uptown LLC, two of the defendants. There's also several others represented by other parties. By other counsel, I'm sorry.
Go ahead.
Leslie Terry here, also with Mr. Luckett on behalf of Massage Heights and Pegasus.
All right. Eric Johnson, go ahead and state your name. Eric Johnson, please state your name. Is he on this case or not? I thought he was on this case.
He is a defendant, Your Honor.
Mr. Hertz, are you here on this case as well?
Eric Johnson is here.
Okay. And Mr. Hertz?
Judge, I'm not making an appearance.
Mr. Hurst is observing. He's a law student, and he's part of the plaintiff's team, but he's a law student observing.
Okay. Sounds good. Let's go ahead and proceed. Let me go ahead and take this off of Zoom, or off of